Hi, and welcome back to another episode of Sidebar Social. I'm your host, Jennifer Grinke.
Always with that. That means I'm the co-host, Dana
This
Stewart.
is my co-host.
Welcome back.
So, Dana, I heard you had a really interesting day yesterday. You want to tell us about it?
I did. I went to jail.
Okay.
Yeah. No, this time I'm visiting a client. So, yeah, it was interesting. Had to go to jail. Had to talk to somebody about their case. And, yeah, it was... What it reminded me is that freedom is very important. Do not go to jail. You would not survive there.
I don't think so.
Yeah, it's way too dirty.
Is there like a spa in jail?
There's no spa. You're not getting your cucumber water. There's no yoga.
No cappuccino?
No Pilates machine.
No Pilates.
There's no reformer. Yeah, you would not like it. But it was good. I got to leave, so that's important too.
Okay.
But she is
You're
still
two
there.
for two?
Yeah, but she's still there, unfortunately, for a while. I feel like it's... the jail experience. We've got a guest on today who frequents jail as an attorney, which is for the record, not...
Yeah.
Appreciate that caveat.
Yeah, just a caveat. So let's welcome Ryne Sandel. He's a friend of ours. He's a criminal defense attorney, a partner at Whalen Law Office. Welcome to the show.
Thank you, guys. Happy to be here. And yeah, I will mirror what you said. Going to jail can be a very fun experience when you're walking out of the door. Yeah,
Right.
that's the best part about visiting any jail. I've been to plenty of them.
When you have the tie and the briefcase and you get to leave.
You get to leave. Yeah, hearing those doors slam behind you on the outside is a pretty good feeling.
So we've got you on today. We want to have a pretty nuanced discussion about protective orders.
Mm-hmm.
So we have worked together, our firm, your firm, for years now. A lot of crossover between your clients, our clients. We share clients, basically.
Correct.
And I think there's a lot of confusion about protective orders. What do they mean? What do they do? So maybe we just take it high level and kind of look at maybe initially what is a protective order, and we can break down some of the types of protective orders and how long they last for. How's that sound?
I like it.
Okay. Jen likes it. I think we're good.
All right. Yeah, and I think there's a reason why I think there's a lot of confusion, and that's because protective orders are one of those areas of the law where you see a whole lot of changes pretty much consistently. 10 years ago, if you would have asked a lawyer, hey, can I go get a protective order, you would have gotten a very, very different answer than if you were to ask for one today. Whether it's the requirements, what's required, what do they do, how effective they are. So they're constantly changing. And so, yeah, I'm not surprised that there's a lot of confusion. And people use terms like protective order, restraining order. They use them interchangeably because the normal person who doesn't deal with them on a day-to-day basis doesn't know what the difference is. So, yeah, I think it's a really good topic, pretty topical, and we can do a pretty good deep dive.
So with protective, let's just break it down then. We've got a final protective order, which we see a lot on the family law side, like a civil protection order can be granted up to 2 years, a period of 2 years. The laws changed recently where previously we would have to prove to a judge that not only did family violence occur, but that it's likely to occur in the future. But that now has changed. You want to shed some insight into the law change there, Ryne?
Yeah, so starting off kind of with the easiest question, what is a protective order? It's pretty simple in concept. It's an order that a court issues where you say, Judge, I need protection from this person, right? So the protective order is just the judge issuing that order that says, all right, I agree with you, you need protection. And so you and anybody else that is in your immediate family that might be in danger are issued kind of a protective bubble around yourselves, and you're protected from whoever the target of that protective order is, right? It's just an order that they have to stay away, they can't contact you. There's a whole list of conditions that can be put on a protective order, but in general, that's what it is. And Dana, to your point, you're right that it used to be the case that if the judge was going to issue a protective order, you had to prove two things. You had to prove to the judge, family violence has occurred. In other words, this person is a family member of mine through a dating relationship, a marriage relationship, something, and they have been violent, physically aggressive towards me in the past. But you also had to prove that it was likely that family violence was going to occur in the future. And that's where a majority of protective orders failed, because a lot of times, if the couple had broken up, if the divorce had been finalized, or if the divorce was even in progress, and they don't live together anymore, the person that was named could say, well, I'm not even around them.
Right.
I'm not going to commit family violence. I don't have any opportunity to. And so a judge would agree with that and deny the protective order. They have since very recently done away with that second prong. So now all you have to do to get a protective order I say all you have to do like it's easy. We'll get into how easy it is later. But all you have to do is prove to the judge that family violence has occurred in the past. And if the judge agrees with that, then the law gives them authority to issue the protective order for, like you said, up to 2 years.
And why do you think the law change occurred? Right. What are you seeing real world practice?
So this is one of those situations. You saw it a lot with kind of tort reform back in the 90s. You're seeing it now where when society as a whole starts to pick up on a problem or a weak area in the justice system, the pendulum will swing and overcorrect way hard in the other direction. So right now in the news, you're kind of constantly seeing cases of family violence that unfortunately result in death or something seriously tragic happening to the person that was complaining about their spouse. You saw it with the Gabby Petito case that was not too long ago. There's a Hulu documentary that just recently came out about a case up in Michigan where a person had been stalked for over the course of a decade, was denied a protective order, and then the person that she was seeking protection from ultimately kidnapped, raped her, tortured her in a bunker that he had created.
Wow.
And then as of taping just yesterday, we saw a story in the news where there were two 17-year-old girls that were trying to get, I believe they were 17. I know that the perpetrator was a 17-year-old. But they were seeking protection from an individual who had been stalking them. They were denied a protective order. And unfortunately, those two girls are now deceased because he attacked and killed them, running them over with his Jeep. And so you see these stories, and they are stories that the public is fascinated with. They have that morbid fascination with things like this happening. And so as a society, we say, how could we let this happen? And so the legislatures answer to that is, well, we need to make protective orders way easier to get, right? Because we can't be having our judges deny protective order and then something terrible happens. So almost every legislative session, you see something happen where protective orders become easier and easier to get because no judge wants to be the one that denied the protective order and then something bad happened.
Yeah. And I think the issue that we see in our cases, since it's divorce, they don't obviously like each other anymore, is that you can really use it as a weapon to your advantage in the divorce case.
100%.
So that's just kind of something that we look out for.
It happens a lot where it's weaponized. I mean, in many cases it's needed, but other times people will embellish or play into that or even set somebody up. We see this too where one spouse is kind of baiting their spouse to have that snap back that, so they provoke them, then they record, or now I was attacked and now a protective order is issued and now we have to get you involved.
Yeah, it's definitely the flip side of the coin, right? And you see it anytime there's something in the law that becomes easier to get, you'll see it start to get weaponized. And it's not just with divorces or family law. We saw it a lot back in the COVID times, right? When banks and the federal government issued those PPP loans, they made them actually really, really easy to get. And there was a good reason for that. They wanted to get the money into the hands of small businesses as quick as they could so that they could keep those businesses afloat. So the barrier to apply for and get approved for the PPP loan was really, really low, which of course opened it up to billions of dollars worth of fraud, right? And so we're seeing that same thing where protective orders, there's a very good logical reason they should not be incredibly difficult to get for somebody who needs protection. They should be easy. It should be something that anybody that feels the need to be protected can go apply for and get. However, the flip side of that is because they are easy to apply for, because they are somewhat easy to get, they can be and often are weaponized with false allegations.
Follow us and join the conversation on Instagram and YouTube at Sidebar Social.
And we're talking about a final protective order, but oftentimes I think we should talk to the audience about the process doesn't always start with applying for a final protective order.
Right.
So what we see a lot is if there was a couple that was in a relationship, there's alleged domestic violence, somebody gets arrested. Can you walk the audience through what you typically see with the magistrate's emergency protective order and what that is?
Yeah, so anytime somebody is arrested for a domestic violence type issue, right? Whether it's assault, family violence, Class C, Class A, whatever it is, if it's assault and it's domestic in nature, the magistrate judge who sets the bond, which is the amount of money that it's going to require to get that person out of jail, will issue an order of emergency protection, a magistrate's order of emergency protection. We say MOEP just because it's easier to say that. What that is it's kind of like a mini protective order. It does the same thing as a final protective order. It orders that person. You're not allowed to go near them. You're not allowed to talk to them. It'll either say you can't talk to them at all, or it just says you can't talk to them in a threatening or harassing manner.
Yeah.
It'll also protect, like if there are children, minor children live in the home, you can't go near them either. You can't go to their place of work. You can't go to the school. You have to stay completely away. So it does everything that a final protective order does, but it's temporary. It usually only lasts 61 days unless it's a felony or like an aggravated assault type offense. But the key thing is it happens automatically. It happens without a hearing. The person that's accused doesn't get a chance to give their side of the story. It just happens. Because there is this idea that we need protection right away. We need kind of this cooling off period where both sides can kind of get away from each other, think of where things are, and then decide. That 61 days is meant to let the person decide, do you want to apply for a more long-term protective order? Is everything getting reconciled? Is it getting sorted out? It gives that time for both parties to kind of consider what their next options are. So that's typically how we see it start, is there's an arrest. That person typically can't be released from jail until they're served a copy of the order of emergency protection. And then that order exists for some temporary period, and it gives us time to kind of circle the wagons and figure out where we need to go from here.
Yeah, and I know times we've worked with you because sometimes those orders will affect possession. And so let's say the violence was, dad against mom or mom against dad. Sometimes it's not clear whether the child's included as well. And so could you kind of talk us through like what you do in those situations on the criminal side?
Yeah, absolutely. And that's another one of those situations where especially magistrate judges will typically err on the side of caution. So even if it's just a dispute between mom and dad, if there are minor children, 9 times out of 10, the magistrate judges will name them as protected individuals just because they're not sure. Their job is not to figure out exactly what happened. Their job is not to dive deep into the facts. They're just going to make sure that everybody is safe. So they're going to name those kids as protected people. So if you're, let's say, your dad, you get issued a protective order. You can't go around mom or your kids. You can't have custody. So no matter what those family court orders say, you get these weekends or you get these holidays, that's gone until you do something about those protective orders. Now, there are ways around that, not without a judge agreeing to it. So what we would typically do is work with the client to file a motion with the magistrate judge asking that those conditions be modified so that the person can have access to their kids and have custody. Most magistrate judges will require that the alleged victim agrees to that request. So they will want to hear from them, what are your thoughts? Are you okay with them seeing their kids? And again, especially in this area, if that victim's not okay with it, most magistrate judges are just going to say, look, I'm sorry, I have no idea what happened, but I'm going to err on the side of safety and you're going to not see your kids for 60 days, which is a pretty harsh reality
Really
for
harsh.
some people to face. But again, it's because we've seen that shift of nobody wants to be the judge that undid a protective order and then something terrible happens.
And that magistrate order of emergency protection, typically 31, 61 days, but it can actually be up to now, I think, 121 days.
Yeah, especially in serious cases.
Right.
Yeah, absolutely.
And so that's a long time for somebody to go without seeing their kids, which I feel like is when we usually get involved.
Correct.
The client comes, hires us, hey, I got arrested. There's this order of emergency protection, and they come to us like, what do we do? And oftentimes the protected party, let's say it was the wife in that scenario, because you said the husband got arrested. She may have her family law attorney file for divorce, file for an emergency protective order in the divorce case. And now we have to coordinate with you to make sure that we're kind of maximizing our efforts to protect both the criminal side and the family side.
Right.
Can you talk a little bit about why that's important?
It's really crucially important because there's so much overlap between the criminal case and the family law case at that point. Not in the sense that the criminal case can use a family court ruling against a criminal defendant. That's typically not allowed. But let's say the protective order that in our hypothetical, the wife has filed, that gets set for a hearing. That will almost undoubtedly get set for a hearing far before the criminal case is resolved. I mean, you're talking months for the criminal case to get resolved, and that protective order is applied for within the first 60 days, and the court will typically set that for a hearing within a couple of weeks. So that protective order hearing happens really, really quickly. at that hearing, as we've often talked about, part of your best strategy is going to be to have your client testify and say, this is what happened. There's a lot of reasons why that might be a really terrible idea from the criminal law perspective. Not even necessarily because we think our client did anything wrong. It's just because at that point, because of the way discovery works on the criminal side, we haven't gained access to almost any discovery. We don't know what's out there. We don't know what the witness statements say. We don't know what the police state records say. We don't know what the body camera footage shows. We haven't seen any of that. And so we're going into a hearing blind. And I think any lawyer, no matter what type of law they practice, will know going into a hearing and having a client testify blind when you don't know what the other side has is just a terrible idea.
It is.
Because what you could end up doing, and this is, I had this conversation a lot with my criminal clients, people don't understand that in these he said, she said cases, right? There's not going to be any evidence of what happened, right? They'll always say, well, how can I get convicted of this? There's no evidence. Well, testimony is evidence, right? What the other person says is evidence. And so if we unintentionally put our person up on the stand and they testify and they corroborate parts of that other person's story without realizing it, because we don't know what their story is at this point, we're making it immensely difficult for us later to attack the credibility of that accuser, because now we've basically said, yeah, everything they said up to that point is true. And in a case where the only evidence that we're disputing is what that person said, and the only evidence we have to show is what our person said, it makes it really, really, really difficult. And so that's a big reason why we all have to kind of come together and collectively decide what's the strategy going to be. And is this a situation where we can afford to go on full attack mode on this protective order at the expense of the criminal case? Or do we need to take a pause and maybe just say, look, as bad as this is, we need to just kind of let whatever's going to happen, because we don't want to win the battle and lose the war.
Yeah, meaning that we may have to, unfortunately, take a hit on the family law side to help set you up to do what you have to do to try to protect the client's potential freedom.
100%. And because at the end of the day, protective orders come with a whole lot of collateral consequences. There's a bunch of things that happen if you are issued a protective order, but all of them are temporary in nature. On the criminal side, the collateral consequences for getting convicted of an offense like this are permanent, forever. I mean, even if we're talking a Class C misdemeanor, so punishable by fine only, no jail time, it's the equivalent of getting a speeding ticket, okay? If you're convicted of a Class C misdemeanor that involved family violence, it doesn't even have to have the word family violence in the crime. If it involved family violence and you take a conviction for it, that means for the rest of your life, you are a prohibited person for guns and firearms. And I know here in Texas, that's a big deal. So you can't go hunting. You can't have your own gun for personal protection for life for a Class C misdemeanor that was essentially a ticket because we did something at the protective order stage that we probably should not have done.
Yeah, that's scary.
Mm-hmm.
Can you quickly define from your perspective or to the audience the difference between, because we typically see a lot of family violence cases that come in where it's a Class A misdemeanor, but help the audience understand that difference between why someone may be charged with a Class A versus a Class C, which is more equivalent to like a traffic ticket.
Yeah, absolutely. It's a question I get a lot too. So in Texas, you have 3 levels of misdemeanor. Class C being the lowest, Class A being the highest, Class B being kind of right there in the middle. They have various ranges of punishment. Class C, it's punishable by fine only. You can't go to jail for a Class C misdemeanor. That's your speeding ticket, your public intoxication, minor in possession of alcohol, those sort of things. Class B, typically punishable by up to 6 months in the county jail. Class A misdemeanor, punishable by up to 1 year in the county jail. And then there's fines, obviously, associated with those too. In Texas, assault is a choice between either a Class A or a Class C misdemeanor. There's no such thing as Class B assault in Texas. It's either a Class A or it's a Class C. Class C assault is what we say assault by offensive contact. So that's intentionally causing contact with somebody that you or a reasonable person should have known is offensive. So this is what we typically see in like the divorce case or a domestic disturbance. If you spit on somebody is a big one. That happens a lot. If you smack the phone out of somebody's hand.
Yeah, I've seen that.
If you grab, her purse and her keys so they can't, leave the house or whatever. Those type of things where you're not making physical contact with the individual, you're really touching an extension of them, or you're doing something that doesn't cause pain, doesn't cause injury, but it's nobody would want that, right? That's Class C misdemeanor. Class A is any assault that causes bodily injury, and that's where we get into this big debate with clients because I didn't injure anybody. According to the legal definition, injury just means causes pain. So if you're ever, and hopefully you're not, if you're ever in a situation where police are responding to a domestic disturbance and they're asking you what happened, they're going to ask the complaining person, when they did that, did that cause you pain? Did that hurt? That's a magic word.
Yeah,
because
I've seen that in police reports.
You've
Yeah,
seen
they
it. Did
ask
it
it all
cause
the
pain?
time.
They always ask it, and that's why. Is because if the answer to that question is yes, it hurt or it caused pain, now you're a Class A misdemeanor. Doesn't have to leave a mark. Doesn't have to draw blood, doesn't have to leave a bruise. If the answer to did it cause physical pain is yes, now you're at a Class A misdemeanor.
Facing up to a year in jail.
Facing up to a year in jail.
Which after my visit to a client in jail yesterday, I could say 1 year is way too long.
That's way too long.
Yeah.
Yeah, way too long.
To connect with today's guest, attorney Ryne Sandel, you can find him as The Gamer Lawyer on Instagram, YouTube, and Twitch.
What's your advice? Because a lot of times we hear situations, husband and wife are in the house, they've either filed for divorce or about to file for divorce. So there's just a lot of arguing going on sometimes. And husband or wife, one of them will kind of set the other one up and call the police. And then the police come. I mean, do you advise people talk to the police at that time?
Absolutely not. And a big reason why is because
Wait, hold on. You didn't even hesitate.
No,
Yeah, you was like,
no, absolutely
Don't
not.
talk.
And it's mainly because police are trained very well to do a job, right? And they have to assume that they're walking into a potentially dangerous situation. They don't know any better. They don't know you. They don't know that I would never hurt my spouse. They don't know that, right? They can't assume that. That's how you get the headlines like the one out of New Jersey, right?
Right.
So the first thing that they will typically do is they'll separate you and the other person. You go to that room, you go to that room. I'm going to talk to you first, then I'm going to talk to you, right? So by the time they're asking questions to you, you have no idea what the other person has said. So you don't know, again, kind of to our point earlier, you don't know what facts you need to refute. You don't know what facts you should agree to. You don't know, right? So there are a lot of ways that situation can go very, very poorly for you. I typically tell people it's almost similar to a DWI stop in the sense that if police, especially in today's world, if they respond to the scene of a domestic disturbance, there is a incredibly high likelihood somebody's getting arrested. Just because, again, they're going to play it safe. And they know nothing bad can happen if one of y'all is in jail. So somebody's getting arrested. So the idea is by not saying anything, I mean, you be respectful, you be polite. If they require you to do something like we're going to take some photos or we're perfectly fine, but you can say, look, I'm not going to give a statement unless I have a lawyer here with me. But I am willing to leave and I'm willing to get out of here and we can all just cool off. Because if the story they're getting from the other side, if they're not really sure that an assault has occurred and then you give them the out of, look, I'll just get out of here. We don't need to be around each other tonight. That's usually your best option because a lot of times they'll say, all right, that's fine. Why don't you pack a bag, go to a friend's house, don't come back tonight. If we have to come back out here tonight, you're going to jail. But once you start giving a story and then those stories don't match and they contradicting one another, at that point, they're going to be left with, well, we got to take somebody, And at that point, everything's high emotion, high stress. And so you don't know, you're not going to be putting together the most coherent of stories. You're going to be rambling a little bit. You're going to be angry. You're going to be aggravated. You're going to be scared, nervous, whatever. And so you're not giving them the most cogent of timelines to follow. And so it's just never a good idea to talk to them at that point.
Yeah, and I've seen it in police reports too, where they're interviewing each party, and there may be a question of, well, did you touch her? Or him? Either way, but in like, oh yeah, I may have like shoved him or her when they were coming at me, and then now they've admitted, and I've seen that then lead right to the arrest because you admitted to contact.
Then they're searching for those keywords, and the keywords is, did you cause physical contact? That's all they need, right? Because even just if you brush by them in the hallway and bump them with your shoulder, that's at bare minimum enough for a Class C. And they can arrest you on a Class C misdemeanor, even if it's just a Class C, because public safety concerns and getting you. So by giving statements, oftentimes you're going to be admitting to offenses that you had no idea was a crime. Like, you didn't know that that was illegal, but it was, and that's what they're looking for.
I know in our cases, when we go to try to get an initial ex parte protective order, the client has to fill out a declaration or affidavit, and they have to give their sworn statement as to what occurred that is family violence. And I feel like that's kind of a check on the system as to whether or not, you get a feeling from the judge as to whether or not this rises to the level of family violence, because it seems like even though the pendulum's swinging, family violence is still a high burden. Would you agree with that from what you've seen?
Yeah, I would. And that brings up a good point of, when we have a client, because we often have clients that, let's say they are the victim of a false accusation, right? And so then they immediately want to go on the aggressive. They want to go on offense and say, well, what can we do to get back at them, right?
Yeah.
And so you have to have that conversation of, look, there are things that as your lawyer we could do. We could apply for a protective order against her, or I had one client where he got into it with his ex-wife's father. He wanted a protective order against the father. So you walk them through that, but those carry inherent risks too. Like you said, when you're applying for a protective order, you're making a sworn statement under oath, penalties of perjury, all that stuff applies. And now you're locked into that story. So in the sense of, if you've got a client that really does need protection, that's a no-brainer. You fill that out, you swear to it, you get the judge to grant it. But if you've got a client where you can just get the sense that, okay, I know you're going blood for blood, you want your pound of flesh, my job and a lot of times what I do is I'll counsel them on, here's where this could go poorly. Because let's say we have that hearing and the judge disagrees. The judge doesn't find you credible and says, I don't believe you. I think you're making this up, or you're weaponizing the system. That's going to look double bad, later on down the line when I'm trying to convince a prosecutor that, no, we're reasonable. She doesn't have anything to worry about from us.
Yep.
Like, well, then why on earth did you levy another false accusation? So it's a good conversation.
I think it hurts in the family law case too. So we have a pending divorce or custody case. We try to get the revenge protective order. It gets denied. Well, that same judge now is hearing the family law matter, and they remember, I don't really trust what this person said, and there's definitely long-lasting implications of that.
Yeah, because I know as a criminal defense lawyer, I will all the time, if there's a protective order hearing and the judge denies it and says, I don't find the complainant credible, the very first thing I'm doing, and I think if I don't do this, I'm being ineffective, is I'm calling the prosecutor on the criminal case. Say, hey, just so you know, the judge just called your key witness not credible. And I'm making sure they're aware of that. And so that's going to have a huge impact on the criminal case. So there's always a give and take on, strategy. And again, that's just why it's so important to have those conversations.
So I think if we wrap this up, one important thing to note is if you're facing protective order, or maybe if you need one, or if you've got one issued against you, the coordination between your criminal defense attorney and your family law attorney is paramount. Like, it's absolutely crucial.
Super, super, super important, because there's so much that goes into it that even if you know what a protective order is, you may not be considering it from all angles.
And have you had a situation where you could never reach the family law attorney, or you didn't know who was involved on it? There was no coordination?
Often. And it's one of the more frustrating things, because I never know if what I'm doing is going to help or hurt the family law case. And then there might be an order that just pops out of nowhere that I was not prepared for. And now I'm scrambling on a criminal law case trying to figure out, what do I need to do in order to try to mitigate against this? Because now the DA has it as evidence and I've got nothing I can do but just kind of swallow it.
So give the audience a little insight into your pre-law background, because you approach, I think, dealing with your clients different than what we've seen with a lot of other attorneys, and specifically criminal defense attorneys. Your approach is different and I think effective. Where did you come up with the magic sauce?
So when I was at A&M doing my undergrad, I actually got my undergrad in psychology with minors in philosophy and sociology. And
You're thinking, man.
I love people. I love people, and I love the study of how people think and interact, because I just think that's fascinating. And so as I'm practicing law, a lot of what I do is focused around why a person is reacting in a certain way, or what would persuade or convince this person to do this, that, or the other thing, because I think that is the core of what I do. I think there's a reason why lawyers are called attorneys and counselors at law. I think there's a high focus on counselor and less of a focus on attorney in a lot of the things that I do, because most of the time, I spend a lot of time in courtrooms, but 80% of my time on any given case is in a conference room or in an office with a client and just having a real conversation about some hard truths that they need to come to terms with and what we're going to do about them. And I think that you can't have that unless you have at least some base understanding of how that person's thinking and where they're coming from.
Makes sense. Well, Ryne, thanks for coming on, and thanks for all the help you do for our clients.
Yeah,
Like,
thank
you've
you.
been great for so many clients we've had, helping educate us and working collaboratively. It's a great team, so we do appreciate you.
100%. It's my pleasure. And likewise for you guys. It's so good to have a team of family lawyers that when I have a client in that's having a family law issue, it's without hesitation go see Dana and Jen. And I know you guys are on top of it and they'll be in good hands. And that's one less thing I have to worry about. So it definitely goes both ways.
Ryne, thanks again. We enjoyed having you on, and we'll see you in the courtroom and hopefully not in jail.
All right, bye, everybody.